Hello everyone, I am Shilpi and in this video I will discuss about the doctrine of basic structure. This is a very important topic of constitutional law. Moreover, frequently questions comes in judicial services examinations, UPC examinations regarding doctrine of basic structure. So, let's start. There are three fundamental questions which I hope that at the end of this video you will get an appropriate answer to it. Number one, whether fundamental rights are amendable. Number two, what is the extent of exercising amending power of Parliament under Article 368? Number three, what is the basic structure doctrine? These are the list of cases which I will discuss, and also some controversial amendments like First Constitutional Amendment, 17th, 24th, 25th, 39th, 42nd, and 52nd amendments which will be covered by me in this video. At the very beginning, let me explain you Article 13 and Article 368. Article 13 says that Supreme Court has power to declare void any law which contravenes fundamental rights. यानी कोई भी ऐसा लॉ जो फंडामेंटल राइट्स को वायलेट कर रहा है, उस लॉ को सुप्रीम कोर्ट के पास पावर है अंडर आर्टिकल 13 कि उसको नल एंड वॉइड डिक्लेयर कर दे, कैंसिल कर दे. Article 368 on the other hand says that Parliament has power to amend by way of addition, variation or repeal any part of the constitution. यानी पार्लियामेंट अंडर आर्टिकल 368 अपना पावर को एक्सरसाइज करते हुए कोई भी कॉन्स्टिट्यूशन का पार्ट को चेंज कर सकता है, चाहे वो फिर फंडामेंटल राइट्स ही क्यों ना हो. In exercising power under Article 13 and Article 368, there was a clear-cut conflict between the Supreme Court and the Parliament. We will realize one thing at the end, that these cases are nothing but just to establish supremacy over one wing upon the another. So, let's begin with the cases. Parliament, using its amending power under Article 368, has inserted Article 31A and 31B in the Constitution. The main object of inserting this article was to abolish zamindari system. Moreover, 9th schedule was also added to make laws acquiring zamindari unchallengeable in the court. This amendment curtailed the fundamental rights to property guaranteed under Article 31 in order to do quick implementation of important measures of agrarian reform passed by state legislature and immuning them from court's jurisdiction. लोगों को इस अमेंडमेंट से ऐसा लगने लगा कि उन लोग के फंडामेंटल राइट्स टू प्रॉपर्टी को पार्लियामेंट इन्फ्रिंज कर रहा है. फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट को चैलेंज करते हुए शंकरी प्रसाद वर्सेस यूनियन ऑफ इंडिया 1951 में ये क्वेश्चन उठा कि क्या पार्लियामेंट अपना पावर यूज करते हुए अंडर आर्टिकल 368 में कोई भी फंडामेंटल राइट्स को अमेंड कर सकता है. सुप्रीम कोर्ट ने डिसीजन दिया कि हाँ, पार्लियामेंट अंडर आर्टिकल 368 फंडामेंटल राइट्स या कोई भी कॉन्स्टिट्यूशनल आर्टिकल को अमेंड कर सकता है. As such, the Supreme Court very clearly held that the Parliament, using its power under Article 368, can amend fundamental rights, and the word law in Article 13 only is an ordinary law made in exercise of legislative power and does not include the constitutional amendment in exercise of constituent power. Therefore, constitutional amendment will be valid even if it abridges or take away fundamental rights. Parliament enacted 17th Constitutional Amendment Act 1964 in which various statutes were added in 9th schedule. इस अमेंडमेंट एक्ट को समझने के लिए थोड़ा बैक जाना होगा. सुप्रीम कोर्ट ने द केरला एग्रेरियन रिलेशन एक्ट 1961 को स्ट्रक डाउन करते हुए कहा कि ये पर्टिकुलर एक्ट रियोतेरी लैंड के ऊपर अप्लाई नहीं होगा. रियोतेरी लैंड के ऊपर अप्लाई नहीं होगा का मतलब कि गवर्नमेंट इस लैंड को एक्वायर नहीं कर सकता है क्योंकि ये स्टेट नहीं है. इस पर्टिकुलर वर्डिक्ट के बाद 17 अमेंडमेंट एक्ट पास हुआ जिसमें केरला एग्रेरियन रिलेशंस एक्ट 1961 के साथ और बहुत सारे ऐसे स्टैट्यूट्स जो कि राइट टू प्रॉपर्टी को कर्टेल कर रहा था, इन सारे स्टैट्यूट्स को 9th शेड्यूल में डाल दिया सो दैट कोर्ट कैन नॉट इंटरफेयर बाय जुडिशियल रिव्यू और कोर्ट इन सब एक्ट को स्ट्रक डाउन नहीं कर पाए. सो इसके बाद सज्जन सिंह वर्सेस स्टेट ऑफ राजस्थान में 17 कॉन्स्टिट्यूशनल अमेंडमेंट को चैलेंज किया गया. In this case, again the question came that whether Parliament has the power to amend the fundamental rights, including right to property or any other fundamental rights. The Supreme Court once again held that Parliament, in exercising its power under Article 368, can amend fundamental rights. So, Parliament अपने power under Article 368 के अंदर fundamental rights को amend कर सकता है. Minority opinion was given in Sajjan Singh case by Hidyatullah Justice and Mudholkar Justice. हिद्यातुल्ला जस्टिस ने कहा कि उनके लिए ये एक्सेप्ट करना बहुत मुश्किल है कि फंडामेंटल राइट्स जो कि फंडामेंटल है, जो कि इनएलिएनेबल है, वो पार्लियामेंट के हाथ में मात्र एक ऐसा चीज बन गया जिसे वो जब चाहे तब चेंज कर सकता है. मुधोलकर जस्टिस ने भी ये कहा कि हर कॉन्स्टिट्यूशन का कुछ एक फंडामेंटल फीचर होता है जिसे चेंज नहीं किया जा सकता और इसीलिए पार्लियामेंट आर्टिकल 368 के अंदर सब कुछ चेंज नहीं कर सकता है. द ओपिनियन ऑफ हिद्यातुल्ला जस्टिस वाज द बेस ऑफ गोलकनाथ केस. In Golaknath versus State of Punjab, 17th constitutional amendment was challenged. Majority overruled Shankari Prasad and Sajjan Singh case and held that fundamental rights cannot be amended under Article 368. Fundamental rights is in transcendental position and if court hold that Parliament can amend fundamental rights, India would pass under totalitarian regime. This fear made majority to take decision that Parliament cannot amend fundamental rights under Article 368. Therefore, for the first time, it held that Article 13 Clause 2 law includes constitutional law as well as any law passed under Article 368 will be subjected to Article 13, that is, judicial review. Thus, Supreme Court declared that any law which violates fundamental rights will be void. So, सुप्रीम कोर्ट ने यहाँ क्लियरली हेल्ड किया कि कोई भी लॉ जो पार्लियामेंट इनेक्ट करता है अगर वो फंडामेंटल राइट्स को इन्फ्रिंज करता है सो वो लॉ इनवैलिड है. Moreover, in this case, only doctrine of prospective overruling was applied. ये डॉक्ट्रिन ऑफ प्रोस्पेक्टिव ओवररूलिंग इसीलिए अप्लाई हुआ क्योंकि अगर रेट्रोस्पेक्टिव ऑपरेशन दिया जाएगा तो सिचुएशन बहुत केओटिक हो जाएगा. कोर्ट ने क्लियर किया कि whatever laws were enacted by the parliament before this particular case will be valid. However, parliament cannot make any such law which take away the fundamental rights after this case. Parliament, in order to neutralize the impact of Golaknath case, enacted 24 Constitutional Amendment Act 1971, in which Article 13(4), which provided that this article will not apply to constitutional amendment made under Article 368. Moreover, amendment was done to Article 368 also, declaring that Article 13 shall not apply to any constitutional amendment under Article 368. The word power of Parliament to amend the Constitution and procedure thereof was replaced in place of procedure of amendment of Constitution. Thus, after 24th Amendment Act, it is clear that constitutional amendment which takes away fundamental rights shall not be brought up in any court. Along with this, 25th Constitutional Amendment Act 1971 was passed. In this particular amendment, the word compensation was replaced by amount. Moreover, 31C was added to protect laws made under Article 39B and C, Objective Principles of State Policy, from judicial review. Thus, primacy was given to this article over fundamental rights under Article 14, 19 and 31. Next come one of the very important case of constitutional history, that is Kesavananda Bharati versus State of Kerala. This case is also known as Fundamental Rights case. In this case, 24th and 25th Amendment Act was challenged by a writ petition under Article 32. This case was heard by 13 judges and The majority opinion are highlighted here, which one by one I am going to explain you. First of all, Golaknath case was overruled, and now it is held that Article 13, the term law which is used, does not include the constituent law. As such, Article 368 Parliament can abridge fundamental rights or any part of the constitution. इसका मतलब पार्लियामेंट के पास पावर है कि वो फंडामेंटल राइट्स को अब्रिज कर सकता है अपना 368 पावर को एक्सरसाइज करते हुए. Next, power and procedure to amend is in Article 368. Hence, limitation upon amending power must be found from Article 368 itself. The court held that whatever procedure, whatever power which is given under Article 368 is given there, and if any limitation is to be imposed upon the amending procedure, it is to be given in Article 368 itself and nowhere else. Next, Justice Sikri held that Parliament can, while using Article 368, change any provision of the Constitution in order to carry out the object which is given in preamble or directive principles of state policies. As such, if there is reasonable abridgments of fundamental rights, it can be effected in public interest. इसका मतलब है कि पार्लियामेंट चाहे तो आर्टिकल 368 के अंदर कोई भी प्रोविजन को, कॉन्स्टिट्यूशन के कोई भी प्रोविजन को चेंज कर सकता है अगर उसको प्रीएम्बल या डायरेक्टिव प्रिंसिपल्स का कोई मेन ऑब्जेक्ट को कैरी करना हो तो. और अगर ये पर्टिकुलर रोल प्ले करते हुए अगर फंडामेंटल राइट्स किसी भी तरीका से वायलेट होता है तो पब्लिक इंटरेस्ट में वो पार्लियामेंट ऐसा कोई भी एक्ट इनएक्टमेंट बना सकता है. देयर इज नो इशू इन दैट. Next, very important point is that there is no unlimited amending power and subjected to one qualification, that is fundamental features cannot be amended. कोर्ट ने ये कहा कि ये तो सही है कि पार्लियामेंट कोई भी फंडामेंटल राइट्स को अमेंड कर सकता है, लेकिन एक रेस्ट्रिक्शंस डाला पार्लियामेंट के ऊपर कि फंडामेंटल फीचर्स को पार्लियामेंट चेंज नहीं कर सकता है. हर कॉन्स्टिट्यूशन का कुछ फंडामेंटल फीचर्स होता है और उस फीचर्स को पार्लियामेंट आर्टिकल 368 के अंदर भी चेंज नहीं कर सकता है. So in this case, the court held that what are the fundamental features? Number 1 is supremacy of the constitution. Next, republican and democratic form of government. Secular character of the constitution was also held as a basic structure. Separation of power, federal character of the constitution was also included as a basic feature of the constitution. Now we can say that parliament can amend any part of the constitution, but अगर ये क्वेश्चन अराइज होता है कि whether वो particular amendment basic structure को destroy कर रहा है, then it is left to the court to decide. That means judicial review was reserved by the court. यानी कोर्ट अपने जुडिशियल रिव्यू के पावर के अंडर चाहे तो ये डिसाइड कर सकता है कि पार्लियामेंट कोई बेसिक स्ट्रक्चर को डिस्ट्रॉय कर रहा है या नहीं. अगर बेसिक स्ट्रक्चर डिस्ट्रॉय नहीं कर रहा है, दैट मीन्स द अमेंडमेंट इज वैलिड. नाउ द वेरी इंपॉर्टेंट एंड वेरी इंटरेस्टिंग पॉइंट वाज देयर whether there is a list of basic feature. Now the thing is that there is no list of basic feature, as there is no final, it is not final as such. Court can expand it in each case if any conflict arises. इसका मतलब एक कोई conclusive list नहीं है basic feature का, और टाइम टू टाइम अगर कोर्ट को लगता है कि ये पर्टिकुलर प्रिंसिपल को बेसिक स्ट्रक्चर में डाला जाए तो कोर्ट उसको अमेंड करके डाल सकता है उस डॉक्ट्रिन ऑफ बेसिक स्ट्रक्चर के प्रिंसिपल्स में. सो सुप्रीम कोर्ट हैज वेरी नाइसली आंसर्ड द two questions. First is that in Golaknath case it was held that whether all fundamental rights are not amendable. However, in Kesavananda case it is clarified that fundamental rights are amendable subject to basic feature. Next important question was that in Golaknath was that can Parliament under Article 368 rewrite the new constitution? So in this case it was cleared that it can do so. However, it does not modify the basic feature and cannot go beyond the doctrine of basic feature. As such, the Supreme Court upheld the validity of 24th Amendment. So, Parliament can amend fundamental rights subject to basic structure doctrine. And regarding 25th Amendment was it held that it was also valid to the extent that Article 31C applied to limited cases of legislation only. But the judicial review cannot be taken away in case of conflict. That means court reserves the power of judicial review, and if there is any violation done by the parliament regarding the basic structure doctrine, the court has power to declare is at invalid. Kesavananda Bharati case was known as the high watermark of judicial creativity. After that, Parliament enacted 39 Constitutional Amendment Act 1975. In Article 329A, Clause 4 was added. The main reason for adding this was to validate the election of Prime Minister Indira Gandhi, which was actually declared invalid by Allahabad High Court on ground of corrupt practice. So, the main reason of amending this act was that to withdraw the election from scope of judicial review. इसका मतलब कोर्ट में किसी भी इलेक्शन का पिटिशन को सुनवाई नहीं दिया जाएगा. Next, to void the High Court decision which declared the Indira Gandhi election to Lok Sabha as void. And the last one was to exclude Supreme Court jurisdiction to hear any appeal. यानी सुप्रीम कोर्ट का कोई पावर नहीं है रिगार्डिंग इलेक्शन मैटर में कोई भी अपील सुनने का. इस कॉन्स्टिट्यूशनल अमेंडमेंट को चैलेंज किया गया इन इंदिरा नेहरू गांधी वर्सेस राजनारायण. इसको चैलेंज करते हुए the court has declared in this that clause 4 was totally unconstitutional because it was against free and fair election, which is an essence of democracy. The apex court included rule of law, judicial review, free and fair election, jurisdiction under Article 32, and equality of status and opportunity in the list of basic structure doctrine. So now it is clear after this case that though an attempt was made by the parliament to oust the jurisdiction of the court in election matter, but the Supreme Court has held that in order to give free and fair election and to protect democracy in real sense, the court has the power in interfering in the matter of election through judicial review. The decision given in Indira Nehru Gandhi case was very disappointing for the parliament. As such, the parliament again made under 42nd constitutional amendment added two clauses in Article 368. First clause, that is clause 4, was that no amendment of the constitution shall be called in question in any court. यानी कोई भी amendment जो किया गया है constitution को या वो फिर या fundamental rights ही क्यों ना हो, उसको कोर्ट चाहे तो उस पर्टिकुलर मैटर में कोई भी डिसीजन नहीं दे सकता है. Next was clause 5, which imposed that no limitation on the constituent power of parliament to amend by way of addition, variation or repeal. That means पार्लियामेंट का पावर है कि वो कोई भी पार्ट को अमेंड कर सकता है और उसके ऊपर कोई भी लिमिटेशन नहीं हो. इसका मतलब बेसिक स्ट्रक्चर को भी चाहे तो वो अमेंड कर सकता है और उसके ऊपर कोई भी रेस्ट्रिक्शंस नहीं होगा. इसके साथ आर्टिकल 31C was also widened to cover all directive principles. इसका मतलब जो कि खाली 2 आर्टिकल को प्रीमेसी दे रहा था, अब it is made clear that all the directive principles will be included to cover under Article 31C. This particular constitutional amendment was challenged in Minerva Mills versus Union of India in 1980. This amendment was challenged on the ground that it again destroyed the basic structure because clause 4 and 5 clearly said that the parliament has the power to amend any part of the constitution including the basic structure, and this amendment cannot be called in question in any court. इसका मतलब कोर्ट चाहे भी तो इंटरफेयर नहीं कर सकता है ऐसा कोई भी अमेंडमेंट में, चाहे फिर वो बेसिक स्ट्रक्चर ही क्यों ना हो. In this case, the court struck down clause 4 and 5 as invalid because it destroyed the basic feature. So, the Supreme Court held that basic feature of the Constitution is an essential element which cannot be changed. This judgment made it clear that Constitution is supreme and not Parliament. Parliament is just a creature of constitution and has all power from it, including power to amend. 31C, which was amended, was declared unconstitutional as it destroyed the basic structure of the constitution by excluding judicial review from the law affecting directive principles. And harmony and balance between fundamental rights and directive principles is an essential feature of the constitution. In Women Rao versus Union of India, Supreme Court clearly held that Article 31C, as it stood prior to 42nd Amendment, will be valid, and all directive principles will not be given primacy over fundamental rights. However, only Article 39B and C will be given primacy over fundamental rights. After this, 52nd Constitutional Amendment Act 1985 was enacted, which actually added anti-defection laws in 10th schedule in order to prevent the defection of members of parliament and state legislature from one political party to another and destabilizing government in the process. In this amendment, Para 7 deals with that if any member is disqualified, it is to be decided that actually he has disqualified or not by the chairperson or speaker, and their decision will be final, and the court have no jurisdiction in such matters. This particular amendment was challenged in Quijota Holohan versus Zachilo because the jurisdiction of the court was ousted in the matter of deciding that whether a person is actually disqualified or not. As such, the court held that this provision, that is para 7, is unconstitutional as it violated one of the basic structure of the constitution, which is judicial review. As such, court's jurisdiction cannot be ousted in this matter, and the court has power to decide that whether a member has actually disqualified. So, Article 368 is subjected to two limitations. One is procedural limitation, next is substantive limitation. Under procedural limitation, जो भी procedure दिया हुआ है under Article 368, Parliament को वो procedure पूरा करना पड़ेगा अगर उसको अमेंडमेंट करना है तो, और अगर वो प्रोसीजर फॉलो नहीं करता है तो कोर्ट के पास पावर है कि वो अमेंडमेंट को स्ट्राइक कर दे. नेक्स्ट, सब्सटेंटिव लिमिटेशन में कोर्ट ने ये क्लियर किया कि पार्लियामेंट चाहे तो कुछ भी अमेंड कर सकता है कॉन्स्टिट्यूशन का पार्ट को, बट बेसिक स्ट्रक्चर को टच नहीं कर सकता, और अगर ऐसा किया तो कोर्ट के पास पावर है कि उसको अनकॉन्स्टिट्यूशनल डिक्लेयर कर दे. सो फंडामेंटल राइट्स can be amended to the extent that basic structure cannot be amended. Thus, from the entire discussion, it is clear that although Constitution confers amendment power upon Parliament, but ultimately it is the Supreme Court which is to finally interpret the scope of such power and spell out any limitation, if any, on amending power. I think from this video, now the concept that what is doctrine of basic structure, whether fundamental rights can be amended is clear. I hope that this video will help you in understanding the entire concept of basic structure doctrine. Thank you.